Welcome back to the Talk Tonight. Our children will read about this day in their history books one day. It seems likely that will occur. Two landmark decisions handed down by the highest court in the land tonight. Tonight, we're joined by William Weizsäck, a visiting professor at the Syracuse University Law School, a legal and constitutional historian, and Megan and I have already been peppering him with questions here during our commercial breaks. There's not enough time to even fully explain it all, but first of all, thanks for being here. And let's do one case at a time here. DOMA seems to be the big decision today. If you could rank the two, what does that mean today?
Well, DOMA means that the federal government no longer has authority to define marriage as being exclusively for men and women, as DOMA between man and a woman, on the grounds that it discriminates against same-sex couples by denying them the equal protection of the laws under the Fifth Amendment, which is a restraint on the powers of the federal government.
Does there need to be a national law created protecting same-sex couples in some sort of form? Or is that likely to happen?
No, it's not likely to happen, and it doesn't need to happen. This is an issue that belongs primarily to the states, and I think one of the great things about both of the decisions today is that the Supreme Court has remitted this issue back to the states where it belongs, because questions of domestic relations, including marriage and divorce and custody of children, have always traditionally been for the states to resolve, not for the federal government.
And so, looking at Proposition 8 in California, which said no to same-sex marriage, this ruling today doesn't say yes to same-sex marriage by the Supreme Court, correct?
It does not. A useful way of thinking about this California Prop 8 case is to kind of imagine a spectrum where at one extreme, the United States Supreme Court might have held that states cannot prohibit same-sex marriage, that the 30 states that currently prohibit same-sex marriage statutes and constitutional amendments are unconstitutional. At the other end of the spectrum, the court might have held that the Prop 8 was entirely constitutional and that the states are fully free to enact legislation like Prop 8. Either one of those extremes would have been highly controversial and would have embroiled the Supreme Court in the kind of ongoing controversy that Roe v. Wade and the abortion issue has produced. And I think the court wisely and in a very conservative way declined to go to either of those extremes. There would be, for one thing, there would be absolutely no support, I think, among the justices for a holding that the Constitution required states to permit same-sex marriage. I don't think anyone in the court feels that way.
Yeah, they all feel the states deserve that power.
On the other extreme, I think 3 of the justices, maybe 4, would have argued that Prop 8 would be entirely constitutional, that states can prohibit same-sex marriages, but the wisdom of the court's decision not going there and resolving the case on the standing issue is that the court did not get itself involved in the substantive issue at either of those extremes and simply withdrew from being involved on the grounds entirely justified that the people who were pushing the case before the United States Court of Appeals for the Ninth Circuit and the United States Supreme Court lacked standing, which means that they had no basis for being parties to the case at all.
Were you surprised at all by the Supreme Court's decisions in either of the cases, or did they get it right here?
That's 2 questions. Number 1, no, I was not surprised. I predicted the outcome in both cases. I seldom am right in my predictions. This time I was. And the second question is, did they get it right? Yeah, they got it absolutely right. I think these are great outcomes in both cases.
And you're also a historian in addition to a legal scholar. How will we look back on this day in the spectrum of this same-sex marriage issue?
I'll predict that 20 to 30 years from now, we will look back on the statutes and constitutional amendments that prohibit same-sex marriage with the same kind of shock and revulsion that we look back on the segregation statutes of the 1940s, and we'll be asking ourselves, how could we do that? Why did Americans think that way when they did? But that's evolving. It's as a matter of social and cultural evolution, and I think that the Supreme Court is right to allow that to continue to evolve and not to try to resolve it prematurely in a judicial manner.
We could continue to pick your brain all night. Thank you so much for being here.
Truly my pleasure.
Thank you, Professor. Excellent explanations tonight. Talk continues in a moment.